Today, I'm going to discuss some case studies in data-driven journalism. So, data-driven journalism is an innovative approach that leverages data analysis and visualization to enhance storytelling and provide deeper insights into news stories. Here, I will discuss three different concepts that are associated with the rise of data-driven journalism. They are net neutrality, data protection, and privacy issues. So net neutrality, the basic premises of net neutrality is this: it is an open internet platform. So it has full resources of the internet, and the means to operate it should be accessible to all individuals and companies. Then, indiscriminate access to data. It means information disseminated through internet must be accessible to all. Third, all internet traffic should be treated equally. Internet service providers cannot change e-content or block the users for the sake of their own vested interest or profit-making intent through World Wide Web Foundation, it has been declared. The Web Foundation was established in 2009 by web inventor Sir Tim Berners-Lee. According to him, I quote, "We believe that the web is a public good and that access is a basic right. Our work focuses on securing and enhancing three rights of access, voice, and participation." Our team of more than 30 experts comprises around 20 different nationalities working from 4 hubs around the world. We work in close partnership with over 150 organizations to reach into around 60 countries. Our annual Web Index, a study covering 86 countries, produced the world's first ever overview of net neutrality in 2014. Each packet of data transmitted on the web must be treated equally by the entire network without censorship or prioritization for any political or business reason. This applies equally to negative measures, that is, blocking or throttling content or services, or positive incentivization, for example, paid prioritization of data or zero rating of specific content or services. Now, equal access to all sites. Same data cost to access a site, there should be no price differences. Then, no zero rating, which means toll-free data or sponsored data. So, mobile network operators or mobile virtual network operators and internet service providers will not charge end customers for data used by specific applications or internet services through their network in limited or metered data plans. So, the debate surrounding net neutrality in India occurs or surrounds the freedom of speech and expression. So, Article 19 of the Indian Constitution guarantees all citizens of India the right to freedom of speech and expression. This applies online as well as offline. Any restrictions placed on access to platforms of data are tantamount to a restriction of freedom of expression. citizen focused markets. It means tampering with net neutrality could undermine the competitive functioning of both telecoms and content provider markets, resulting in poorer internet experience for citizens. Then there are different constraints of net neutrality. For example, allowing paid prioritization could lead to cartel type collusion between telecoms and OTT platforms, thereby squeezing out smaller players as they try to enter the market and stifling innovation. So, the success of Digital India will depend heavily on efficiently functioning broadband markets that deliver high speed internet access at affordable prices to all Indians. So, they said we will deal with the complex issues surrounding zero rating in a separate way. In 2011, India adopted the new IT rules, that is IT rules 2011, that supplemented the IT Act of 2000. These rules made it mandatory for internet intermediaries to remove objectionable data or objectionable content within 36 hours of receiving complaint. In 2011, government also drew flack as it asked major sites like Google, Facebook and Yahoo to pre-screen content and remove any objectionable defamatory content from going live. So, the advancement of the technology and the dynamism of legal world provides outlook of privacy and data protection issues in this recent era or digital era. So, privacy is something that is not to interfere to the interest of others. So, privacy has become a concern for every individual due to technological advancement, and it also emphasizes narrowly for protection of data. So, data protection emphasizes individual liberty, and these individuals' liberty is under threat by the interference of the stranger. The activity of the stranger to the individual's activity by any means is required to halt. So, the basic legal requirement of any new phenomenon can be validated through the Constitution. The Constitution of India has given more emphasis on right rather than duty. And for giving emphasis data protection, it also considers as a right-based approach. As India is developing state, it needs some time for the effectiveness or implementation of the new area of law. The data protection issue mainly attracted by these areas which are right to privacy, right to information, technology and Indian Penal Code, national security, intellectual property, corporate affairs and consumers, etc. So, the objectives of this discussion is to examine the present legal status of privacy and data protection in India as a matter of right. The constitutionality of privacy and data protection has given so much importance in these recent dates or days because the reason behind it is this, that it is required to provide a special status in the legal framework. The efficacy of present legal framework is needed to analyze, to give a sophisticated protection of the privacy issues. It has to explore the nature of right that has been affected by this data intervention to an individual by encroachment of data. The new IT law also explores the nature of right that has get affected to an individual by encroachment of data protection in relation to other law. The idea to put forward this theme is to associate the idea of India with other countries. So the concept of data protection is taking the importance or giving the importance or important place in worldwide. Gradually, all nations are embracing the concepts of data protection and implementing laws regulating the use and misuse or abuse of personal information. This terminology of data protection is deriving from the German term Datenschutz. The data protection concept is more or less connected with the individual's privacy. It is typically reserved for a set of norms that serve a wider range of interests than simply privacy protection. It is not privacy only which has been taken into consideration for data protection. There are variety of other issues, partly overlapping concepts have been invoked too, particularly those of freedom of speech and expression, liberty, personal liberty, and autonomy. In the concern, the first and foremost condition come in mind for the individual that data protection is a right. An emerging issue in this area is the extent to which such laws should protect organizations and groups or individuals. This data protection concept mostly accepted about the individual's information protection. The scope of data protection is also the protection of information laws to data subjects, defined narrowly as living individuals. Thus, in matter of corporate body, such as a limited company has no right of access to any information. The concept of data protection has some directive in different countries. The European Union has sophisticated data protection law. Under EU law, personal data can only be gathered legally under strict conditions for a legitimate purpose. Furthermore, persons or organizations that collect and manage the personal data of any individual must protect it from misuse and must respect certain rights of the data owners that guaranteed by EU law. Now, the absence of generic privacy legislation in the US is a major concern to the EU nations, and this will make determination that the US ensures an adequate level of protection unlikely. While there are concerted efforts in the administration calling for privacy legislation covering various types of data, the large number of data in Congress dealing with privacy issues suggest that the US may continue to take a piecemeal approach to privacy legislation. Now, the constitutional status of India. This constitutional status of India with regard to data protection law, it has certain provision like freedom of speech and expression, which has been given in Article 19(1)(a) and Article 19(1)(ab). Similarly, right to life and personal liberty. These provisions have its effect to the right to privacy as a fundamental right. There are a number of cases also which establishes the right to privacy as a fundamental right. The conceptuality of this proposition has also connected with the new dimension of the data protection. The linkage between this privacy and data protection are interdependent to each other. The right of data protection is the closely related with the information of an individual. In a case of MP Sharma versus Satish Chandra, Supreme Court held that the contention that search and seizure violated Article 19(1)(a) of the Constitution, the court took the view that a mere search by itself did not affect any right to property and through seizure affected it. Such effect was only temporary and was a reasonable restriction on the right to privacy. Then, the right to privacy has been developed in the constitutional sphere of India under Article 19(1)(a) and Article 21. In other words, the context, the right to liberty under Article 21 of the Constitution is also addressed by Shubha Rao J. in the case of Kharak Singh versus State. So, to conclude, I must say that all these three different concepts, net neutrality, data protection laws, and the debates surrounding privacy issues are interconnected, and different cases when published in media platforms raised all the above mentioned concerns, and the Supreme Court of India has given different directions based on the specific case. Hence, it can be said that the domain of net neutrality, individual privacy, and data protection is, although typically complex, the IT laws should be more stringent, but not at the cost of citizens' right to freedom of speech and expression, right to individual liberty, and privacy as well. Thank you very much.